must be oral. One of Mr. Jego Wajiro is pointing out that you will arrive at a dangerous position if this court were to apply the rules of civil procedure to say that you can do this, you cannot do that. So that the oral application that we are making is permitted by the law. It doesn't require a notice. All that it requires is that we have informed the court. The presumption being, you want somebody to be detained, you must be in court, even for purposes of any clarification by the court as to this or the other issue. Second point arises from Article 50 of the Constitution. Under Article 50 of the Constitution, the 52K, an accused person has a right to abuse and challenge the evidence presented by the prosecution. Under Section 36A, to present the evidence or the reasons that would justify the detention of an accused person. It is the law that expressly says, do an affidavit to present specified information, specified evidence. You read that in the context of the provisions that we've just raised, 52K, the person whose liberty is sought to be curtailed has a right of necessity to challenge what is contained in that affidavit. And this being criminal proceedings, such challenge can be made by the right to cross-examine on the evidence that is being presented. Otherwise, if that were not to be the case, the prosecution would be able to say the affidavit is not controverted, which would lead us to an absurdity. Everybody is interested in their liberty. So an accused person always controverts the basis upon which their detention is sought. And for avoidance of doubt, under that section 36A of the Constitution or of the CPC, you will note, Your Honor, 36A subsection 4. It says as follows: in determining an application under subsection 2, the court shall consider any objection that the suspects may have in relation to the application and may. So we end up there, that the suspect may, the objection that the suspect may in relation to the applications. You will notice, Your Honor, and it is for a very good reason, that the section that requires the prosecutions to do an affidavit does not require an accused person to do an affidavit. It requires the accused persons to object. The cross-examination is our mode of objection. Because when the gentleman takes a witness stand, then he'll be able to clarify on oath the basis upon which the constitutional rights of a Kenyan citizen should be curtailed or limited. Last point, Your Honor, before I sit down to Mr. Kidota to make a point or two, is this: that For purposes of the procedure that is set out, the court, and this is a general rule, the court in determining the particular matter, if one were to assume for just 1 minute that the prosecution is right, that we need to give a reason why we need to cross-examine. First of all, our starting point, the Constitution is the sole reason we need to give, and our liberty. It is the liberty of the accused person that is being taken away. We cite the authority of the Constitution. That is sufficient authority. But more importantly, if as the contents of the affidavits are anything to go by, for purposes of this cross-examination, Your Honor will note that when it is, you look at the evidence, the information that is required for purposes of Section 36A of the CPC, for example, inform us when was the offense alleged committed? What have you undertaken in terms of investigation? Who are the witnesses that you allege will be interfered with? What else do you need to justify the 14 days? All this information is lacking. These are statutory information that is required to be presented by way of an affidavit before this honorable court can curtail the rights of the accused persons before you. Therefore, because the affidavit before you does not contain the information, the evidence to warrant what they are purporting to do, the defense in objection has a right to demand and assert their constitutional right to object by way of cross-examination of the deponent. Your Honor, you are most obliged.
Your Honor, just to agree with my learned seniors on the constitutional basis for the right to challenge evidence by an accused person, I want to quote, because the prosecution has brought before the court some high court decisions. My name is Sakumpa, Your Honor. The prosecution has brought high court decisions purporting to limit cross-examination in this case. Your Honor, I also have an authority, that is the Law Society of Kenya versus Faith Waigwa. It's a 2015 Kenya law report, where the High Court found that
Is that the case of LSK?
Law Society of Kenya versus Faith Waigwa. It's a 2015 decision, EKLR. The High Court found that that where cross-examination is necessary, where the accused person needs to delineate their case. And I want to read from paragraph 13 of that decision on what the court says. And the court says that there are specific questions directed at each defendant in respect of specific above.
The first one, you get it at paragraph 6.
Let me take a name, okay?
Kirago Waduta. The first reason, you find it at paragraph 6 of the supporting affidavit. It says that upon quick search, the respondent was found in possession of, among other items, as per the inventory attached hereto and marked JS1. No inventory is attached to this affidavit. Therefore, it is important that the deponent tells the court what is in the inventory and where is the inventory. Another reason, for the benefit of the court and the suspect and all of us, is to explain to the court the basis, the legal basis of this application. Because applications for detention, for pre-charge detention, are founded on section 36A of the CPC. You're not looking at the application, that is not the law under which the application is made. It is made under section 11A of the National Police Service Act, which section does not exist.
Section?
Under the National Police Service Act, number 11A of 2011, actually there is no section. It is the whole of National Police Service Act.
So there is no section 11A.
Basically, it is not section 36A of the CPC under which this application is made. So basically, the National Police Service Act does not give the court power to grant the orders that are sought in this application. And the power has not been properly invoked. Therefore, the suspect cannot appropriately respond to such an application without cross-examining the deponent so that he understands the basis of the application and then he can apply the law to that application. You know, another question that for the benefit everyone would want to know and the court would like to understand is the connection between the deponent of this affidavit, that is C.I. Desterio Omukanga, based at the Directorate of Criminal Investigations, Investigation Bureau, and the offenses of terrorism that are being investigated, that are done under the ATP. You need also to elaborate that.
Let's repeat that. The connection between?
Yeah. He says that he works at the Directorate of basically DCI headquarters, Investigation Bureau. The offenses being investigated by him are under the prevention of the Porter. So essentially, we've been here the whole day. We've heard how Porter is investigated and the distinction between the two. Yona, those alone, before you make any orders about this application, those are very vital questions that need to be answered through by way of cross-examination. Therefore, we urge you to allow the application. Thank you.
Yes, Your Honor, I also wish to address you.
He's the last one.
Yes, I'm the last one. I was acting alongside Mr. Kabata Maula. Your Honor, I want to draw your attention to section 151 of the Criminal Procedure Code.
Section
151. As led together with section 150 of the Criminal Procedure Code.
Is it 151?
And 150, 150 and 151. CPC. And I wish to read section 150. Verbatim. This is power to summon witnesses or examine persons present. And it reads, a court may, at any stage of a trial or other proceedings under this code, summon or call any person as a witness or examine any person in a case. So, what this provision of the law is saying is that these proceedings are well categorized by section 36 being pre-trial detention proceedings, as lightly put by my learned friend, Mr. Wabuti. And that section From that section proves the authority of the court to have a witness cross-examined. I want now to proceed to section 151. Your Honor, we must treat all authorities presented before us with caution. Why? These are authorities in civil proceedings, and where there is a written law in form of a statute, it takes precedence unless the same has been annulled by the court. These are sections which are still breathing. Section 151, evidence to be given on oath, as the evidence which has been given on oath in this affidavit of the inspector. So the section says that every witness in a criminal cause or matter. So the law envisaged a scenario like this, where it will be a cause or a matter, shall be examined upon oath. And the court before which any witness shall appear shall have power and full authority to administer the usual oath. So, there is nowhere when it comes to production of evidence on oath, the Criminal Procedure Code envisaged a silent witness. Someone just comes, sneaks in a document, and disappears and says, "Don't ask me any questions. Deal with the document before you." Personally, I would have loved to cross-examine this evidence of the inspector, and sought to establish why. Because I'm curious as to who commissioned this affidavit. From my search on the advocate search engine, I would like more details. I would like to know something about that, Your Honor. So, Your Honor, the magnitude of these proceedings and the nature of the application before you and the order it seeks gravitate in favor of you and the court allowing the defense or the respondents to cross-examine the applicant's witness. And why is that so? As I wind up, it has never been the nature of the court or the makers of the law to close evidence out. Your Honor, I'm aware that the court will be interested to get as much evidence as possible to make a just ruling on this matter. I cede the floor, Your Honor.
Your Honor, Muge, just one issue. I, on the other hand, say this affidavit is a useless piece of paper. If you look at the jurat, you will see it is not sworn on any day. It is fatally defective and should not be considered at all.
And maybe, Your Honor, for the optics, just to show you that the law cuts both ways, I had one authority where cross-examination was aroused on an affidavit, and the citation is Rapida Kaul. It's an ELC civil suit number 157 of 2015. ELC civil suit number 157 of 2015. It was a High Court of Kenya at Nairobi. It's Lapida. Lapida is a nation name. Rapida Kaul versus Abanas Sai, where the judge allowed cross-examinations of an affidavit.
May I still confirming one small element from the affidavit.
Yona, I'm glad that the council is putting the last authority that I presented. And the position is giving the court is not proper, it's not right. The court declined to give an order for cross-examination
In which matter?
in the authority that he's just mentioned last.
You're not found.
One of the ones that I've shared with the court, I've given the court. You know, you've equally been told about the civil procedure rule, order number 19, rule 2, and that it is not applicable, Your Honor. The reason I was raising that matter on order 19, rule 2, was to compare it with other two constitutional petitions that I've shared, including the Evans-Kidero matter. It was a constitution, a EACC matter, anti-corruption matter, which is criminal in nature. And the court had a similar finding, that cross-examination of a deponent is not a right, and grounds have to be laid, applications made, and responded to before the court can allow that application. The authority that has just been given to the court, Your Honor, that seems to be different, is the authority shared by Council on Law Society of Kenya, Faith Waigwa versus others. You know, the Law Society of Kenya matter that is a ruling. In that matter, Your Honor, specific questions, specific issues had been highlighted, and specific averments listed, and the court had gone through the specific averments listed before then allowing the said application, Your Honor, that was allowed in LSK versus Faith Waigwa 2015 matter. In fact, the authority states that the specificity of the request made by the council through specific questions in respect to specific affirmance given, the court considered to application for cross-examination. The said application, Your Honor, they're telling you that Order 19 Rule 2 is not applicable. The court relied on Order 19 Rule 2 to give that application, which was before a civil matter. It was not a criminal matter, Your Honor. They cannot then have
There is a confusion in the procedure, in the sense that we applied for cross-examination, they responded, then we were just rebutting, rejoinder. So there is no right for them to engage in what they
No,
are.
I made the application.
No. This is not, we have not come to that application. Our application was for cross-examination. They answered at length, then we responded to them. So
I
we have
agree.
no right
I agree,
to
Your
do
Honor.
anything else.
I don't like arguing on matters that are not truthful. I agree. They made the application, I responded, Your Honor.
Yes.
And then they did a rejoinder. But during their rejoinder, Your Honor, they raised new issues.
No.
Which one?
Let me just give my application to the court so that the court tells us whether I'm right on this. All these authorities were shared after we had already given a response. Your Honor. Remember, Your Honor, we said that they had not raised any basis on the application. These bases have just been raised when we had already responded to the application, Your Honor. And the state should not be left without a rejoinder, because that is the law. Whenever a new issue is raised during the response, Your Honor, and this is rejoinder, the last rejoinder, the state cannot be left without an answer.
In which event you would have to say issue that is new. You cannot say everything is new.
I
You
can
say
list
like
that
there is one or two issues that are allegedly new. but he cannot proceed the way he's doing, Your Honor.
And Your Honor, the authorities provided were in response to the ones he provided. On the table.
And in the case he's
One.
deemed to know them. It's presumed that he doesn't know unless you want to
They were in
read otherwise.
response.
You know, we may get that ruling on the issue of listing. I can list the new issues that were just raised.
This is jurisdiction and not compliant. They do not have.
Please, can you allow the court to make a determination?
Sir, there's no right on
No, he has no right.
Yes, Your Honor.
I think he's right to that extent.
Yes.
That when we first made the application to cross-examine,
Yes.
did not lay down the ground. And it has come in pieces through the representation by counsel. I think he gave promises, and I think someone else.
Yes.
Yeah. So we can also wrap up.
Very well, Your Honor. Thank you.
According to those new issues.
That's okay. That's okay.
Thank you. You know, during their response, they've stated that the Civil Procedure Order 19, Rule 2 is not applicable to these proceedings. I totally agree with them. But has that wisdom been borrowed by the courts of law in constitutional petition and in an economic and criminal court matter, which is criminal in nature? And the answer is yes, Your Honor. In the matter quoted of LSK versus Waigwa, they relied on Order 19, Rule 2. And why was this one allowed, whereas my authority says it was not allowed, Your Honor? This is the reason. Specific questions had been given in the application, and in reference to specific affirmance that had been made. Is that the case in this matter? No, Your Honor, they've not done that. Another issue that was raised, Your Honor, and one of the authorities that I shared in a constitutional petition, they also argued Article 50 when we had no right to respond, Your Honor. Article 50 brings the relevance of a matter here that I've shared with the court on constitutional petition, constitutional issues. And the court held that courts ought not to readily permit cross-examination of the deponent's affidavit. Otherwise, if the court becomes too willing to allow for cross-examination, already limited time available for applications would be further curtailed and detrimental. In the premises, I find merit in the objection by Mr. Magolo, the notice to the notice to cross-examine. In this case, they also had given a notice to cross-examine. They were even better, and they were denied the honor. So, Section 151 and 150 of the CPC, and I benefit that this CPC is my bread and butter every day, is not on issue of affidavits or on issues of Article 49. Section 151 and 150 of the CPC is on trial. When can the court call for cross-examination of a witness or examination?
Your Honor, with tremendous respect, I think I'm the one who intimated that to court, and I'm an officer of this court, Your Honor, and it's plainly legal. So it's a bit painful when a learned counsel wants to willfully mislead the court on something which is legal.
Can I just finish my submission? Can I just finish? The court is recording what you said.
The other concern, Your Honor, that we wish to raise in counsel submissions is he was to respond to the grounds which are factual.
New grounds.
This is question of law, the applicability of that section. The court will interpret. Counsel has no audience in respect to the extent of a response that relied on particular responses, because that is what relied on particular provisions of the law. Because when you are responding, I am expected to respond and to reply on the question of law. And you cannot say that because counsel responded and then we did a rejoinder on points of law, then he has a right to respond to those points of law. I think he's abusing and extending his imagination.
If I can finish without wasting people's time.
Just cover up.
Yes, sum up, Your Honor. The ones that you are not able to respond to is Section 150 and 151, which were raised later. And what I'm saying is that these two sections are not applicable on affidavits. They are matters of court hearing when the evidence is being taken, when the trial has begun. That is Section 150 and 151 of the CPC. He also raised an issue on Section 36A of the CPC, Your Honor. These are the issues that were raised.
Okay, you can get leave to say something.
He also raised Section 36A of the CPC and said that this application has no legal basis, Your Honor. And we tell the court to look just at the face of the application. It is predicated upon Article 49(1) F, G, and H of the Constitution. On the right to extend time to incarcerate someone during the investigation stage. That is the basis. This is not a section, this is the National Police Service Act that was quoted there. But the section that is applicable is Article 49(1) F, G, and H of the Constitution. The issue, Your Honor, of unsigned, undated affidavit, that is not true. We have the original copy that was already dated and signed. If they were supplied with the ones that were not dated, we apologize. But the ones that was dated was already the original ones, and we have it before this court, Your Honor. And it is important that this affidavit, I had it and everyone saw me giving them, that we have aside. I was even surprised.
You were dating.
Was not. No, please. Your Honor. So that is equally has no basis, Your Honor, and we submit that we can get the court ruling. Thank you.
Your Honor, with leave of the court, because of the altercation that was happening, just allow me to make 2 quick points, because he has ended up making the situation worse. Your Honor, this is not something that we should be fighting over, for the simple reason that, as my learned colleagues indicated, civil procedure rules under Order 19, they govern civil proceedings, which includes in Kenya constitutional application. So no confusion should be brought by that issue. But with regard to criminal proceedings, my learned colleague Ishmael Moringa has set out that under Article 150 and 151, sections 150 and 151, the Criminal Procedure Code has set out specific provisions to govern the issues of witnesses and tendering of evidence, which is furthered by 36A of the CPC for purposes of the context of the subject matter before this court. The point, therefore, is that you cannot be able to
You know, I don't know whether counsel had
No,
the right
I'm
to
just
address
finishing
the court.
that.
You know, you didn't have the right to address the court, counsel. It's not, Your Honor, and I don't know why we are doing things unprocedurally. I had the right, Your Honor, no, because legally, when new issues are raised, the party at disadvantage is given a right to cross-examine. But after is given the right to address the court. But after that, they do not have the right. I've been patient enough, but
if there are new issues, we re-examine.
Which new
I
issues?
have
Your Honor?
sought leave, and has been granted. Your Honor, so
Your Honor, I don't know whether-
therefore,
I don't know whether
yes, I'm making the last point. I'm making the last point. I'm making the last point with the leave of the court. That last point, Your Honor, that we are making is that when you look at 151, and the work of lawyers is to assist the court to make a just decision. And I'm saying, Your Honor, because we cannot make an important decision like this on ignorance, is that under 151, evidence is to be given on oath. That is actually the key provision. Your Honor, what that means in simple, plain English is that even where the prosecutor comes armed with an affidavit, it is a legal requirement they must take an oath and then indicate to the court that in compliance with Article 36A, I am tendering this affidavit. But that taking the witness stand in criminal proceedings, it is mandatory. There are no two ways about it. You must take an oath to be a witness at all. And they are a witness for purposes of tendering evidence. It is evidence that is the basis of detention. Your Honor, we are most obliged and urge the court to uphold the fact that in criminal proceedings, taking the oath is a must for witnesses.
Since already I need to look at the question. I'm saying it's already 5:23. We may need to retire and make a ruling. And, I think it might not be possible for me to do a ruling and deliver the same day today. So we need to.
You're in the event
Tomorrow.
in the event where perhaps you want to have time to do the ruling, could we then make an application for bail on behalf of our client?
Your Honor, they refused us to do the application for bail and bond.
I don't think
They refused to hear the application for bail and bond.
the application for bail.
After bail, the application will be heard after bail has been granted. No, that Your Honor, is not a good suggestion.
I assist myself with the prayers by my learned friend, Mr. Degwajir, that any criminal trial must have at its back or in the back of its mind the freedom of the suspect. As you retire to write the ruling and possibly deliver the ruling tomorrow, it's incumbent upon the court to entertain an application for bail or bond pending the delivery of that ruling, and even possibly insulating the court against other rulings which may come on its way. So I think, Your Honor, it's not far-fetched to make that application. We are only seeking the freedom of the accused person. This is something that can be done at the police station, the police board, but given the magnitude of the offences that are alleged in this affidavit, it's only fair that we make this application for bail.
I was also talking about time, so that we don't conduct the sittings way past the permitted time. And I believe that application is intertwined with this one.
Yes.
Isn't that so?
No, Your Honor. You know what will happen, Your Honor, when we grant us an opportunity to address you, we'll be able to convince you that these are distinct applications. So distinct to the extent that should you be convinced by the affidavit and the application by the DPP that you need to incarcerate them for 14 days, then you have the authority to cancel that bail. So it will be done to the confinement and the limitation that the application itself has not been urged. To that extent, pending the hearing and examination.
I believe they intertwined.
And Your Honor, also
Allowing one is disallowing the other. Isn't that so?
No, Your Honor. Once you grant us bail today, and then you're convinced by the application that you need to grant more time for them to investigate, then it will be one of the bail terms conditions that the bail will start revoked or suspended following the hearing and successful granting of the application. So it is within your confinement and your ability to entertain our application.
Your Honor, we oppose to that.
Your Honor, a challenge in law, I think it's an application we are making. So kindly, Your Honor, we seek a indulgence.
We're seeking leave to make that.
Yes. So we are seeking leave to make an application.
Your Honor,
And this is what I was about to say. I think
Your Honor,
you kindly.
just to, because now the councils are giving themselves that direction.
No.
We have not. We are addressing the court
leave,
also.
yes.
We are seeking leave. Not unless you are extension of the bench. We are only seeking leave. Kindly. Your Honor, what we are saying,
Let's be courteous.
we are very courteous here, Your Honor. What we are saying,
Not to the extent of arguing the application.
I think let's also mind time that the court is minding. Your Honor, what we are saying, and kindly we seek your patience. In the event that you retire and you grant that ruling tomorrow, the import is the accused person will be incarcerated for day one. So it will be defeatist on our side. That's why we are saying, let's not condemn them to this application, the grounds of the application, without hearing their prayer for bond or bail.
And then consider the time.
Yes.
Just check your watch.
You know, I
My
confirm
phone
that
is
we are
off.
outside the court sitting hours. It's 5:24.
Your Honor, in any case, Your Honor, this is a case that is so unique in the sense that the prosecution has just brought this file at the tail end of the day. Number two, Your Honor, we've had instances where the High Court has even sat on Saturdays in certain cases. So circumstances do permit us to see beyond, slightly beyond, just to make sure that, Your Honor, you uphold the right of the persons before you. So the rights before and the rights that are just about to be denied supersedes the regulations in terms of time, because you are upholding a constitutional provision vis-a-vis a rule that has been created, a median rule. The balance is you hear us on the application for bail, and these are justifiable situations. The circumstances do permit, and you can agree on how much time you can take, Your Honor.
You know, unfortunately for the state, we cannot oppose an application without an affidavit from the IO. So we also require time to do an
Let's
affidavit
make
in
it
respect to that application they are seeking, and bearing in mind the time that is, the time we are.
Just allow me to do a ruling.
Yes, Your Honor, please. Thank you.
And the situation is actually getting out of hand. I can tell you. This is Ruto State. If you see some of us sitting here, by the way, my children, I've been sitting here for I've been sitting in my seat in this time. This is a great issue. I can tell you one kuna hiyo moja alienda huko Kazia kuingia na some state Garissa. That fellow told me, this thing is serious. One,
Imezima. Iko on.
You may permit me to let us allow me to do a short rule. I've said it's now past 5:30 p.m. This court requires time to write a ruling on the application by the team to be sending the respondents to cross-examine number 237017, Chief Inspector the Stereo CAC. The counsel for the respondents have given an indication that they also desire us to make a further application for bond, which the prosecution has indicated will be opposing. As regards the application to cross-examine the deponent, several authorities have been cited, which this court will need to peruse and consider. In considering that it is way beyond the official time now, and the fact that the notice of motion application dated 8 July 2025 has not been had, I will deliver a ruling on the application by the counsel for the respondents tomorrow at 11 a.m. In the meantime, the respondents will be remanded to Mosaic pending the ruling.
Your Honor, kindly, before you pen off, I think it will be also be prudent to indicate that the deponent who we have to cross-examine does also avail himself tomorrow, just in case the ruling goes away.
We further confirm that, Your Honor, that pursuant to your ruling, it will be a hearing of the application. Because you've just indicated that you've just delivered it. That there will be a hearing tomorrow.
It's part of the hearing.
Probably we'll do the ruling, which will give us the way forward.
Before you pen off, you can request probably the officers can record our client chance to be able to make a few contacts. Second respondent works for media station.
Pardon?
The second respondent works in a media station, and when contact is employed, some of the contacts are in his phone, which currently he cannot be able to trace whereabouts. We are requesting if at least the officer, even if you have a provision, he can access his phone to retrieve the contact that he has.
He can only contact using the phone.
No, he doesn't retrieve the contact. But he can lose his job, Your Honor.
I think now that the family is in court, the party is represented, maybe they can get an alternative way because there's an evidence, and we know the volatility of electronic evidence. And therefore, since it has been seized legally, it cannot be released until extraction process. So unfortunately, that is the legal position. He may make other arrangements, and the officers here will facilitate them making other contacts. Maybe
On the issue of the presence of the deponent,
the presence of the deponent, they will avail themselves. That is why they made the arrest, and they should be here when the matter is proceeding.
so maybe I should indicate the deponent to be in court.
Yes,
tomorrow.
Let's be in court.